Saved by the Bell. Me? Really? Okay. Good evening. Today is December 18th, 2024. This is the Malden Zoning Board of Appeals. The Malden Board of Appeal will hold a public hearing Wednesday, December 18th, 2024 at 6:30 p.m. at Malden City Hall, 215 Pleasant Street, room 108, the Herbert L. Jackson Council Chambers, Malden, Mass, on the following petitions. This meeting may be recorded by Urban Media Arts, formerly known as Malden Access Television. The order of petitions, there's only one tonight, will be determined by the chairperson. Before we open the meeting, we'll do a roll call for attendance. Tonight, we have brought out of retirement Kathy Bartlett. Aaron Simpson could not be here tonight. Go ahead. You're on. You're
I
on.
am now. Okay. Kramer?
Here.
Froyo?
Here.
Sherwin?
Here.
Cordoveri?
Yes.
King?
Here.
Bilgan? Here. And Esposito? Here. Thank you. All present.
Okay, and so the first order of business will be to approve the minutes from the last meeting. Has everybody had a chance to review those minutes?
Yep.
Would anybody like to make a motion to approve those minutes?
Motion to approve the minutes? Second.
Motion by Froyo, second by King to approve the minutes of the prior meeting, November 20th, 2024. All in favor?
Aye.
No? Want me to call it separate?
Nope, that's fine.
Okay.
Everybody said aye. Okay, we will move on to the public hearings. For this hearing, we have one member that is recusing himself. So tonight, one of the alternate members will be serving, and I'm choosing Armand tonight because I believe last month Maria, when I wasn't here, Maria served. This is petition 24-013 by Mystic Valley Regional Charter School, seeking an appeal under the Code of City of Malden as amended, Title 12, Section 12.32.040A3, to hear and decide appeals of decisions made by the Inspector of Buildings or other administrative official, specifically the decision of the Building Commissioner, Nelson Miller, dated October 23rd, 2024, regarding the gym project as per plans RES 064150-2024 at the property known as and number 31 Granite Street, Malden, Mass, and also known by City Assessors Parcel ID 133-663-303. So this, I just want to mention in the beginning, this is not, this is kind of an atypical discussion for us, so we are not meeting, we're not discussing a variance tonight. We're deciding whether or not the building commissioner's decision was valid or not. So we're gonna hear from both Mystic Valley Regional Charter School and Nelson and the public, if anybody's opposed or against it, but I just, you know, and kind of seeing some of the material ahead of time, keep it to the decision. We don't care about the setbacks right now. So just keep it relevant, and you're up, Mystic.
Thank you. Am I right that there are 5 voting members?
There are 5, so that's why I started, I think, a minute late, because we were waiting for these last 2 to show
Yeah, no,
up,
that's
so.
absolutely fine. Good evening. My name is Mike Murray. I'm an attorney with Nixon Peabody in Boston, and I do a lot of land use and zoning matters, including litigation relating to them. And I'm representing the Mystic Valley Charter School. I do have a lengthy presentation that is going to get into the setbacks because that is part of this appeal, but I'll try to explain it. fairly lengthy because I know that the board does, and I know that the building commissioner hasn't addressed many requests like this, and I know the board, this isn't a typical matter for the board, so that's why I'm going to try to explain everything the best I can do. Anyway.
Okay.
And I'm happy to answer any questions that you may have. Now, just so you know also, we have representatives from the school here. We have the school's architect, so whatever questions you have can be answered, if not by me, by them.
But again, the decision is just based on his decision, not the plans.
Excuse me?
The decision that we are making tonight is just based on Nelson's decision, it has nothing to do with the plans for the building.
Well, his decision was rejecting our request for determination with respect to the plans for the building. So I will explain all that as I go through it. I mean, those are all fair questions. But I think you're all familiar with the Mystic Valley Regional Charter School, which I'll refer to as Mystic Valley during the presentation. But just in case, it's a tuition-free public school. It's a charter school. Its students are primarily from Malden, Everett, Medford, Melrose, Stoneham, and Wakefield. Mystic Valley students are, Mystic Valley's core mission is to provide equitable opportunities to all of its students, many of whom are minorities. Its goal is to provide them with a world-class education. Mystic Valley has been succeeding in its mission and has produced some of the most impressive MCAS scores in the state. Mystic Valley is financed through local, state, and federal funds, serving just over 1,700 students in grades K through 12 on campuses in Malden. Let me see if I can find the right slide here. Okay. And so the kindergarten is at 576 Eastern Avenue. The lower school, which is grades 1 through 8, is at several different addresses, including 770 Salem Street, 30 Laurel Street, 4 Laurel Street, 729 Salem Street, and 28 Lebanon Street. And the high school, which is grades 9 through 12, is located at Highland Avenue. So why are we here? Mystic Valley seeks a determination that its proposed plans for a gym project at 31 Granite Street, which I'll refer to as the gym project, while slightly out of compliance with certain setback and loading area requirements, should be deemed zoning conforming under the Dover Amendment, which is a state statute that I'll talk about a little later in this presentation. Now, it's important to understand just how minor the deviations are here. As reflected on this chart, 31 Granite Street has more frontage and square footage than are required for the gym project. The gym project has been carefully designed so that it complies with all but a few of the applicable zoning requirements. The gym project will provide a larger right yard setback than existed before Mystic Valley purchased the property, because there had been a couple of structures that infringed more on that setback, and they have been removed. It will have more than double the front setback that is necessary, while also having more open space and significantly less lot coverage than is necessary. The gym project will also be less than half the height that is permitted under the Malden zoning code, while fully satisfying state off-street parking requirements. In fact, pursuant to the Dover Amendment, Mystic Valley could, if it so chose, build a much larger structure on the property. The only nonconformities with zoning will be a 6.6 foot right yard setback instead of the required 10 feet. And with it, there's something called the both setback, and that is both right and left yard setback. If you have if the left yard setback is infringing, it's likely that the both side setback will be as well, and that's the case here. So I kind of group those two together. A 10-yard rear setback instead of a 20-yard setback, and there's a requirement that there be one loading area, but the project will not have a loading area. So those are the only ways in which the project's non-conforming, and those are highlighted in yellow on the chart. And, as I'll discuss soon, none of these zoning nonconformities will affect anybody other than Mystic Valley. Now, I'd like to provide you with a little more detail about the gym project. 31 Granite Street is within a Residence A zoning district in which public schools are allowed by right. In other words, Malden's zoning code imposes no special permit or site plan approval requirement in connection with this project. Now, 31 Granite Street is abutted by a number of properties, and we can look at them here on this chart. Almost all of them are owned by Mystic Valley. Only 24 and 26 Jacob Street, those are the only abutting properties that are not owned by Mystic Valley. Just one slight correction. The area marked 790, that's not owned by Mystic Valley, but it is leased by Mystic Valley. So Mystic Valley, either owns or leases virtually all the properties surrounding 31 Granite Street. Now, the proposed structure. The next several slides include additional plans for the gym project. I'll not spend much time on them, but I did want you to at least be able to look at them. This is the site plan for the project, and it shows both the required setbacks in red and where the setbacks are in blue. And you can look at the site plan later if you want. If you have any questions about it, we can answer them. The next one is the floor plan. It shows you the basketball court and the other areas that will be in the building. Then we have the building elevations. The building height actually under the zoning code is 24 feet because you don't include the roof peak under the zoning code. It could be, the height could be 50 feet. If we wanted it to be 50 feet, it could, but the project was designed to only be 24 feet. And that's another plan showing elevations. Stopped moving, I'm sorry.
Been there many times.
Okay. Now, this next slide addresses why 31 Granite Street is an appropriate location for the gym project. First, as I noted earlier, Mystic Valley owns or leases virtually all of the surrounding properties, so the disruption to other people is going to be minimized. Second, the existing main classroom buildings for the students who will use the gym will abut the rear of the project. And as a result, the traveling between regular classes will stay on the campus and it won't disrupt anybody in the neighborhood. And third, the gym's recreational space will be heated in the winter and it will be cooled in the summer, so that that's going to minimize the need for any of Mystic Valley students to use Trafton Park. So now we get to the decision on appeal. A few months ago, Mystic Valley, it was in September, Mystic Valley met with the building commissioner, went over the project with him, and asked for a determination pursuant to the zoning code that the State Zoning Act's Dover Amendment, which I'm going to talk about a little earlier, just to make sure it's clear, should be deemed to accommodate the minor zoning nonconformities that were highlighted in yellow earlier. On the sides at the left and both side setbacks, the rear setback, and the lack of a loading area. By decision dated October 28th, I'm sorry, it says 28th, but it should be October 23rd, 2024. The building inspector correctly stated, I have previously communicated to you that the project is considered an educational use and therefore does fall under the protections of Massachusetts General Law, Chapter 40, Section 3, otherwise known as the Dover Amendment. So that was correct. The building commissioner also correctly stated that the Code of the City of Malden, Title 12, does not provide a process for the application of reasonable regulations regarding the bulk and height of structures, lot sizes, yard areas, setbacks, open space, parking, and building coverage requirements as specified in, that's the site to the Dover, as specified in the Dover Amendment for protected educational uses. However, the building commissioner also ruled as follows. I have determined that in the absence of a review process within Title 12, a site plan review committee should review the proposed design in accordance with and narrow to these reasonable regulations. The regulations regarding site plan review are contained within Section 12.12.140. And then the building commissioner correctly stated that we had a right to appeal the decision within 30 days, which we did. We filed a timely appeal. So given the building commissioner's decision, Mystic Valley is seeking the following relief from this board. First, a determination that Mystic Valley is not required to follow a site plan approval process. Second, a determination that the building commissioner had the authority to apply the Dover Amendment to the project and to determine that it conforms given how the Dover Amendment works. And third, a determination that the Dover Amendment accommodates the gym project. So we're actually asking you to make that determination too. You would have the option of sending it back down to the zoning commissioner, but you also have the authority to make that decision yourself. So want to make sure that everybody understands this is a proper appeal. Like we really had to pursue our rights. We had to file this appeal, and it's proper to file the appeal. The building commissioner's decision specifically said if we wanted to appeal it, we had to do it within 30 days, and that's what we did. He was correct in telling us that.
Understood. I just want to make it clear to the board, just because it's not a typical case for us, we are determining whether or not the building commissioner's decision was right or wrong. We are not voting on a variance for this.
There is no variance, but
Right.
I'll explain how the Dover Amendment.
I just wanted to make it clear for
Yeah,
the board
yeah.
because it's so atypical for
Yeah, no, that's fine. Okay, so the other reasons why I don't know if there's going to be any dispute on that. If there is, I can come back to the slide, but there's also another section of the code that makes it clear this is a proper appeal, and there's a Massachusetts statute that makes it clear that this is a proper appeal. Now, on the issue of his saying that we should go through a site plan approval process, respectfully, that was incorrect, and we're asking you to overrule him on that. Now, let me just make sure I get caught up here in my outline. Now, there are several reasons for this. Like first, the Section 12.12-140, which is the code provision that the building commissioner referred to. He said, well, first he said there is no site plan approval process. He acknowledged that in his letter. But then he said that we suggest that you go through this process that's set forth in 12.12-140. But that process, by its express terms, applies only to projects in the residential incentive overlay and the residential incentive B overlay districts, and the property is not part of that. So 140 does not apply to this site. In addition to that, Section 12.12.20 specifically says that and I'll sort of summarize it, the full site is there, but the use regulations of this ordinance shall not regulate land owned or leased by bodies politic. And we are a body politic. The Mystic Valley is a body politic under state law. Now, Chapter 12.12 is entitled, and it contains only use regulations. So Section 12.12.140, which is the site plan requirement or provision that the building commissioner cited to, it doesn't apply to bodies politic. It doesn't apply to educational uses. It's specifically exempt from, in the zoning code, from the site plan approval requirement. So under the code itself, we can't be required to go through site plan approval.
When is site plan approval required? Because I haven't seen it really I don't think I've ever seen it come up in my 7 years on the board.
Yeah, so it's in the Residence A, the Residence Overlay District and the Residence Overlay B District. So if you happen to have a qualifying project in those districts, you have to go through site plan review. There's also separate site plan review, I think in Rose Quarry. There's a couple of other provisions. I don't know that, my sense is it's atypical for a project to have to go through site plan review, given how the code is written. But there's no educational use, there's no body politic that can be required to go through it because they're specifically exempted from it within the zoning code itself. I'm going to skip through this slide because it gets a little complicated, and I don't want to complicate things at the moment, but I'll answer whatever questions people have. But I'd like to say that in addition to the fact that no site plan approval process applies here, it would be unlawful under the Dover Amendment to require Mystic Valley to go through a site plan approval process. And we've cited a land court case from 2007, and it specifically says, and it was affirmed on appeal, upon inquiry by this court, none of the parties could cite a decision where a court has not voided a local bylaw that establishes a site plan approval process for a project protected by the Dover Amendment. So for all those reasons, the building commissioner recognized site plan approval doesn't apply. He suggested that we go through it, but the provision he cited to we're specifically exempt from, and by its own terms, it doesn't apply to us. And it would be improper under the Dover Amendment to require us to go through site plan approval.
I'm sorry, can you just read that again? So from what I just heard, the site plan approval process can't deny you.
Well, we can't
But
even
the
go
building
through
commissioner's
it.
set to a certain standard, you know, if it doesn't meet certain rules, but he can send you to site plan review who can't deny you? Is that what that's saying?
Okay, so there's, it gets a little, the bottom line is we cannot be required. Our position, and we think we're right about this under the code and under the state law, we cannot be required to go through site plan approval. The building commissioner did not want to make the Dover Amendment decision himself. I'm going to get to some slides where we explain, and I understand why he didn't want to. I mean, this is not a typical thing that he faces, but the law is pretty clear for, you know, if you do this stuff all the time, if you're a zoning expert, like the laws, we say fairly clear, and I'm going to try to explain that to you, but I understand why he did what he did, but we think he was, you know, respectfully, we think he was wrong to do that, but basically, he didn't want to have to make that decision. He didn't want to have to decide whether these regulations that we don't comply with are reasonable or not. He didn't feel like it was his place to do that. And he wanted us to go through a site plan approval process where others could weigh in on that. But again, we can't, the reality is under the law, we just can't be, like, if we had to litigate this, I'm pretty sure, I have no doubt would win. We can't be required to go through a site plan approval process, especially where the code itself says we're not subject to it. Does that answer your question?
So upon inquiry by this court, I'm sorry, I'm reading that screen.
Okay.
Finger up there.
Yeah.
Upon inquiry by this court, none of the parties could cite a decision where a court has not voided a local bylaw that establishes site plan approval process for a project protected by the Dover Amendment.
So this was actually a gym project that, in Dover, I mean, let me see, actually, it was in the town of Duxbury, I'm sorry. And the project proponent said, you cannot require us to go through site plan approval. And the town of Duxbury said, yes, we can. And the court said, nobody has shown me any site plan approval requirement that's applied to an educational project that has been allowed. They've all been voided.
Okay, so
So
to
that's
me,
a-
that's saying That's not saying you can't do that, it's just saying no site plan approval has been denied under that.
Well, it's saying you can't do, well, the court actually, it voided,
It's saying they can't,
you cannot do it.
see if I got it
Okay.
right.
Yeah, I'm
It's-
sorry.
It's saying, I mean, the way I read it, it's saying that the town doesn't have the power to require by ordinance.
Okay,
That's exactly right. And
Okay.
if you want a copy of the, we have copies of the decision, if you want me to hand them up. But that's
can I-
exactly what it's saying. It's that you cannot, the town can't require it, so nobody can be compelled to go through it. And what it's saying is like, nobody's even shown us any site plan approval requirement that hasn't been voided, meaning hasn't been struck down by the court,
Okay.
when it's presented to the court. If nobody presents it to the court and the educational use agrees to go along with it, that's different. But if the educational use doesn't want to do it and challenges it, this court is saying, look, I haven't ever seen one of these allowed. I'm going to strike this one here in front of me.
Can I ask you a question?
Yes.
I don't want to interrupt the
No,
flow.
I want to answer people's questions.
If, I mean, this is, I know the courts move slowly,
Yeah.
but this is 17 years ago. I mean,
That
has
was
there
my
been
next
any other?
So there's nothing that in remotely similar circumstances where a site plan approval has been allowed. There are certain types of site plan approval that may be acceptable, even for educational uses, but it can't be to impose on someone other than the building commissioner and zoning board of appeals, a discretionary authority to decide whether or not the project can proceed. And I'd be happy to brief that if anybody wanted to, but the law does get a little tricky here, but there is nothing remotely close to, you know, the site plan approval, process that we were suggested to go through that has been approved by the courts, that I'm aware of. And I read almost every Dover Amendment case there is, but you know, there are some that are approved, but none like in this situation.
And are those based on ordinances that, or is it laws that the zoning ordinances that the cities or towns already have in place?
Yeah, so the bottom line is, yes, they're certainly based on laws that were in place. So like, as it stands, there's no ordinance that says we have to do it, so that you can't force us to do it for that reason alone. But where they have one in place, they're sometimes allowed, if they're deemed to be not overly subjective and they're deemed to impose, you know, the type of requirements that Dover Amendment allows. But in this situation, I'm confident that any requirement that we go through something that doesn't even exist right now, by the way, that would be stricken. Does that answer your question?
Yes. Yep.
So now we get to what is the Dover Amendment? I've been referring to it a lot here. Now, the Dover Amendment is a state law within the State Zoning Act that protects a number of uses. And it doesn't protect only, it also protects more uses than just religious and educational uses. It also protects some solar energy uses and various, and protects daycare. But the provision we care about is the one that protects educational uses. And I've quoted it on this slide. And what it says is that you cannot prohibit any educational use, but you can impose I say you, the city, a municipality may impose reasonable regulations concerning the bulk and height of structures and determining yard sizes, lot area, setbacks, open space, parking, and building coverage requirements. And again, Mystic Valley is a body politic. Proposed use is an educational use. That's not disputed, so the Dover Amendment protection does apply. So the Dover Amendment exempts the gym project from all zoning regulations except reasonable regulations concerning the bulk and height of structures and determining yard sizes, lot area setbacks, open space, parking, and building coverage requirements. So those are the only things that can be regulated, and they can only be regulated with reasonable regulations. And I'm going to get, in a few slides down the road, I'm going to explain what a reasonable regulations is here. But the building commissioner and this board have the authority to apply the Dover Amendment analysis. And that's a key point here. Because the building commissioner didn't want to do it, but he's actually, required to do it. And this board, reviewing his decision, has the same authority, under state law, has the same authority that the building commissioner had in issuing his decision. So where there is no process for determining whether the zoning amendment requires a relaxation of the zoning requirement, which there isn't here, and it's very hard to do that because site plan approval requirements are stricken when they're challenged. It was the building commissioner's responsibility to make that determination himself. It doesn't say that in the Dover Amendment. It doesn't say that in the statute we went over. But it does say that in the case law. And the Supreme Judicial Court, has specifically instructed that the building inspector in the first instance, and then this board on any appeal from the building commissioner's decision, is supposed to decide that facially reasonable zoning requirements, facially reasonable zoning requirements concerning bulk and dimension cannot be applied to I'm sorry, I misread that. But basically, the Supreme Judicial Court said it is for the building inspector and the Zoning Board of Appeals to make the determination of whether zoning regulations are reasonable. And that's the Campbell case, which we can give you copies of that if you're interested. And in addition to obviously the Supreme Judicial Court is the highest authority in the state, but there's also that land court case, which we cited a few slides earlier.
If I could just, sorry to break in a minute, so I noticed that was from 1993.
Yes.
There's been nothing more recent.
Nothing on that, on that particular point.
Okay.
It hasn't been modified by the Supreme Judicial Court. It hasn't been criticized. And there's nothing new on that particular point. There are all sorts of ways that in various municipalities that the Dover Amendment winds its way through, which is one of the reasons why this situation is a little weird. But the law is, this is the law. If there's nothing in the zoning code that identifies how this determination is supposed to be made, it's got to be by the building commissioner, and then any review, any appeal is to the Zoning Board of Appeal. And this is a more recent decision than that. It's still, 17 years ago, but it's that land court case we talk about. And it specifically says that the zoning enforcement office is charged with the statutory responsibility to determine what a reasonable regulation of an educational use, what is a reasonable regulation of an educational use. And the zoning enforcement office is, in Malden, it's the building commissioner. So we have the Supreme Judicial Court saying it, and a land court's not going to say anything different than the Supreme Judicial Court, but it's sort of just echoing it. Now, the next question, and like the $65,000 question for us is, how do you determine if a regulation is reasonable? Again, that's not something that the Dover Amendment tells you, so it's something you have to look to the cases. So the Supreme Judicial Court in 1993 noted that the purpose of the Dover Amendment, one purpose of it, at least as applied to educational uses, is to encourage a degree of accommodation between the protected use and matters of critical municipal concern. It says that such an accommodation cannot be achieved by insisting that an educational institution seek a variance to obtain permission to complete its project. So you're right, there's no variance here. We didn't apply for a variance. We didn't have to. I'm going to get to a slide later on. Malden Catholic did apply for a variance about a year ago. They didn't have to do that, but they chose to for whatever reason. No educational institution can be required to seek a variance pursuant to the Dover Amendment. That's what the Supreme Judicial Court says. And how do you determine whether regulations are reasonable? So what the Supreme Judicial Court says is that the applicant is required to show that compelling compliance with the regulations would substantially diminish or detract from the usefulness of a proposed structure or impair the character of the institution's campus, without appreciably advancing the municipality's legitimate concerns. So those are the two, that's a two-prong analysis that we say the building commissioner was supposed to apply and that this board is now supposed to apply if it chooses not to remand it to the building commissioner. And it's also important to consider that excessive cost of compliance with a requirement imposed on an educational institution without a significant gain in terms of municipal concerns might also qualify as an unreasonable regulation of an educational use. So let me just get caught up here. Yeah, so now I'm going to return to some of these charts that I had shown you earlier about dimensional and parking requirements. I'm sorry, loading requirements. Now, given the odd shape of the lot, you can see that on the left, it's an irregular pentagon. It's not a rectangle. The lot itself is an irregular pentagon. It's not possible to build a dimensionally compliant basketball court and gym that satisfies all of the applicable zoning requirements. So we've done our best to comply with as many as we can, and we've succeeded for the most part, but there are those areas in yellow that we simply could not comply with. And next. So what we're seeking, just to, again, to make it clear, is we're seeking a reduction in the left yard setback in the related both side setback from 10 feet, it's required 10 feet, the left side setback is, we proposing it to be 6.6 feet. And the both side setback is required to be 20 feet, and we're requesting it that it be 16.6 feet instead. We're requesting a reduction in the rear yard setback from 20 feet to 10 feet, and we're seeking an elimination of the zoning requirement. We're saying that those three requirements are unreasonable under the two-prong test the Supreme Judicial Court articulated. They're unreasonable as applied to our gym project. Now, so let's go look at the first prong of the zoning, Dover Amendment analysis as applied to the gym project. Compelling conformity with the left side and both side setbacks, the rear setback, and the loading area requirements would detract from the gym project. And, you know, there's a few slides where we explain how important this gym project is to the school, and I'd like to, I'm going to try to speed up my presentation here, but these slides do deal with that. They simply, the school just doesn't have enough space right now. It had a gym before, it does not have one now. It had to use that gym for classroom space. It is one, I think it's the only lower school in Malden without a gym. It needs more space anyway. So this is a very critical project to Mystic Valley. It needs the project, and it's a fair project. Now, just a few more other, because I hadn't mentioned them, some benefits of this project overall. They're going to be able to conduct 2 gym classes at a time with approximately 30 students per class, which means the kids aren't going to, you know, have to go outside in the cold weather or whatever. They're not going to have to cancel class during bad weather. The gym project is also going to provide needed space for school assemblies and other convenings. And it's going to be, but it's important to understand, it's not going to be used for competitive sports games. Like, this project is not going to attract any traffic at all. This project, we've complied with the off-street parking requirement because we want to comply with as many zoning requirements as possible. But this will generate no new traffic, and it actually will add 7 new parking spaces to the area. So there no parking spaces that exist on the lot now. It will add 7, and it's not going to bring any more traffic at all to the area. It's all going to be internal use by the students and the staff. Now, the reality is, we have the architect here who can answer any questions, but it simply is not possible to alter this project and to comply with with the setback requirements. We could eliminate parking, but that means we'd have to have a Dover amendment, a request that you forgive that. And because we know the city seems to like parking, we want off-street at least, even though we're not adding any new vehicular traffic. You know, we wanted to comply with that, but there's nothing else. Like, there's no way that this gym project could proceed, given the shape of the property and the dimensions you need for a functioning gym, so that it's safe for the kids. There's enough space between the end of the court and the walls. There's no way that this could be designed to be in any smaller of a building. Now, the second prong of the Dover Amendment analysis is whether compelling compliance would appreciably advance the municipality's legitimate zoning concerns. And here, it wouldn't do that. The deviation from the left side and interrelated both side and rear yard setback, it's very just the side yard setback. It's very minor, it's only 3.4 feet. It abuts property that's owned by Mystic Valley, so it's only going to affect Mystic Valley. It reflects the elimination of a prior non-conforming right yard setback that we're going to bring into conformity with this new building. It's consistent with the neighborhood. Other nearby properties have even more non-compliant side yard setbacks. And it's not going to adversely affect the side yard setback itself. Like, this 3.4-foot deviation is not going to have any adverse effect on the neighborhood. Now, the deviation from the rear yard setback, it's also minor. The proposed setback is actually more than 10 feet from, for 99% of the building. It's supposed to be 20 feet, but it just can't be 20 feet. The rear of the property abuts two other properties. One of the properties is Mystic Valley's, and the other is property that Mystic Valley leases. So that rear yard setback infringement is not going to adversely affect anyone other than Mystic Valley. So here again, we can see, you can see the dimensions again, and if you look at for the left yard setback, you can see that it's especially minor. It's only a sliver of the left of the building. And by the way, left is if you're facing Granite Street with your face to Granite Street, your back to the building. On your left side, if you look, there's only a very small sliver of the building that does not comply with the 10-foot setback. And if you look at the rear of the building, most of the rear is more than 10 feet, but it's not 20 feet because it can't be. We put the prior buildings on this chart also.
I'm sorry, I don't want to cut you off, but it seems like you're starting to argue for a variance, which is.
No. This is the second prong of the Dover Amendment analysis. Okay. Like, would this serve any municipal interest to force us to comply? And it wouldn't, because the variations, it's not a variance, but the non-compliant components of this project aren't going to hurt anyone. That's part of that, and that's our point. Like, that's not a variance argument. That's our argument as to why the Dover Amendment applied. Now, this is again still the second prong of the Dover Amendment analysis, and you can see we've highlighted in black the parking lot for 4 Laurel Street. That's the only area where the side yard is going to infringe, and again, that's all Mystic Valley's property, so that's not going to hurt anybody. And then you can see on the right, the setback from where the building on 4 Laurel Street starts at 10 feet and increases to 28 feet at the rear corner. This is another slide that shows the right yard setback. We do not need relief from the right yard setback. We're going to be non-conforming, whereas the prior buildings weren't, but we just wanted to give you some sense of what the area looked like. And the rear yard setback, this is, you can see that the setback from the gym building to St. Joseph's is 12 feet to 15 feet from the St. Joseph's parking lot. And the existing 50 Laurel Street rear yard setback is 11 feet to the St. Joseph's parking lot. So we're not talking about any dramatic change at all to this area, and it's all on Mystic Valley owned or controlled property. Now, this is another slide on this, but I'm going to keep going here to shorten it up. Now, I wanted to also just show, like, this was taken from the Malden GIS map online, and it shows the area. And you can see that the large circle sort of in the center, that's the area, and it has like a yellow border around the property in question. That's like a little enclave, really. That's a Mystic Valley enclave. So this is like really going to affect only that area. But then if you look out more broadly at the neighborhood and surrounding houses, you'll see that there are a lot of similar or even more egregious setback nonconformities. So again, the second prong of the Dover Amendment analysis, compelling compliance with the left side, both side setbacks and rear setback, would not appreciably advance the municipality's legitimate concerns. That's the test. Would forcing us to comply appreciably advance the municipality's legitimate concerns? And it really couldn't when you see all these other nonconformities and you realize that ours are no different from them and aren't going to affect anybody else in any event.
Can you just,
Yeah.
I'm pretty sure a lot of those buildings you just showed on your map have been non-conforming before code or zoning was really implemented in this town. So I'm not sure, I feel like you're forcing a lot of your opinions on us. So I would appreciate you being a little bit more open for maybe people that might not understand that. So these are single-family double or duplexes or triple deckers, and they've been non-conforming before maybe this zoning was implemented. So I think yours is a new project. It's a little different. It's a gym, which is quite large of a building, and the scale and the program is very different. So I guess I just wanted to just put that out there.
Well, I mean,
Not as
it's
relevant as maybe.
so. Look, we're not saying that these other properties have to do anything, right? They're legally non-conforming. I'm assuming. Like I didn't research all of them, but I'm assuming that they were built a while ago. They were built when zoning allowed it. Zoning no longer allows it. But if you're going to say would compelling the current requirements, would compelling Mystic Valley to follow the current requirements, would they appreciably advance the municipality's legitimate concerns? A factor in that is that the surrounding neighborhood, for whatever reason, has very similar nonconformities. So, the fact that we're a little closer to the left side, we're less infringing than most of these. The fact that we're a little closer to the left yard setback and rear yard setback, even though they're to our own properties, that's mitigated somewhat to the extent that we don't think it's a problem at all. But to the extent someone were to say, look, this is in a neighborhood of, houses that have much larger setbacks, and this is an aberration, that's really not the case. There's nothing wrong with these houses, but the fact that they infringe more on their own setback, more on their lot line, they're closer to their lot lines than we will be, is relevant,
Well,
It's
they're
irrelevant to the
they're
neighborhood.
grandfathered.
Excuse me?
They're grandfathered, and I just have another question to
Yeah,
ask,
yeah.
and I hope I'm not wrong in asking this, but
No.
you brought up Malden Catholic earlier, and they applied for a variance.
Yes.
To me, I know how I would go on this, this all makes sense to me. Would this have all gone a lot faster if you applied for a permit, got denied, went for a variance? Then if that got denied, claimed over amendment, and I'm sorry if this is wrong to ask, but
No, it's fair to ask. I would say, for the record, it's not.
I'm wondering if they did that because they kind of knew it was gonna be faster.
All right, well, here's what I'll tell you. Like, I don't know, this is my opinion, okay? I think they knew they were gonna get the variance, right? And I think they knew, why not do it? If we're gonna get the variance and we'll get less opposition, like they had, my last slides, and we can go to that, let's just go to that. They had serious zoning violations. Instead of a 20-foot front setback, it was 33.4 feet. Instead of 20 feet, east side setback was 4.8 feet. Maximum building coverage was over. 72,000 square foot project instead of ours is 6,500. The standard for issuing a variance is much higher. It's a much heavier burden. And it would, and if Malden Catholic believed they could be denied the variance, I'm not their lawyer. I can't imagine them going through that. Variances are usually often reversed on appeal, an actual variance, because the standard is so high. You have to show something about the shape and topography of the lot that's different from all the other properties. And the bottom line is, the board granted the variance, it was not appealed, it was not challenged. By the way, I didn't mention that parking was an enormous issue here, too. They were required to have 72 off-street parking spaces. They only had something like 8 or 9. And if they had to satisfy the parking, they couldn't have had a building that was even remotely close to that. So I'm speculating, but I think we would like to make nice, we don't want to be here, and we don't want to have to litigate, right? So we try to do this like the most appropriate way we could. But a variance, like if you have opposition, if you have people who are going to speak against you, if you're politically a less popular applicant, and you have less of a chance of getting a variance, you're in trouble if you seek a variance.
This board's not political.
No, I don't know whether it is or isn't, but what I do know is they did get the variance. I think they probably understood they were going to get the variance, and it's totally appropriate. Like applicants want to get their relief. They want to do it as quickly and efficiently and spending the fewest amount of legal expenses they can do it. We did not believe that a variance, the other thing is, by the way, the precedent, like we can't be required to seek a variance, and if we were to do it for this, and then we had another project at some other point, and it would be easy to say, well, why don't you do it again? And the reality is, the law is clear. I cited that case a few slides back, but it can't, it's a Supreme Judicial Court case. You cannot require an educational use to go through a variance. It's the Dover Amendment, and it's the two-prong, much more forgiving for applicants test. So that's the best I can do, but I don't know anything more than, I don't have anything to offer more than that.
Okay.
Does that answer your question?
Yeah, I think what he's saying,
I'm understanding now why
it very-
maybe they did it the way they did it, because it seems like a lot for,
don't give up your rights. That's,
right.
It's very risky to apply for variance, because
Yeah.
if you have to appeal it, it's a problem. It's a problem. Or if you get the relief and someone appeals it, that's a problem too. That's a problem too. So, we're just doing what we think we're trying to get the project approved. We don't want to step on toes, but that's what we're trying to do in the fastest, most efficient way possible. All right, so anyway, I think I've answered I hope I answered your question. I mean, you're right that we're not claiming that anybody here is, these houses are violate zoning. We're claiming that this is not an aberration from the area, what we're seeking. It's only going to affect us. It's not going to be next to any other
Yeah, but I think
houses.
that's your perspective. Affecting the public good is part of our purview, and also people get to comment on that, people that actually live in the neighborhood, whether they're abutters or not. So there's a lot of, your single perspective is a little different than what we're here for tonight, so.
Yeah, well, they have every right to comment, but the only proper inquiry here is whether the specific zoning nonconformities that I'm identifying, whether compelling conformity with those would appreciably advance the municipality's legitimate concerns.
Yeah, I think you did have a slide that actually listed setbacks and height and other things. Could you go back? It doesn't look like it's in a printout.
Yeah, I'm sorry, what did you want to see?
There was a slide that explained the Dover Amendment, and it did list like setbacks and height
Yeah.
as,
Yeah, but we comply with those, so you're right, but let me just, okay, so here,
not this slide, there was another one I thought that listed.
well, this is, we're subject to reasonable regulations
Oh,
concerning
yes.
the bulk and height of structures and determining yard sizes, lot area setbacks, open space, parking, and building coverage requirements. So to the extent those requirements are reasonable, we're subject to them. So there
Right.
is a height requirement. We comply with it. We're like less than half the maximum height. There's a building coverage requirement. We comply with that. We'll comply with, that's the chart I had given you. We comply with every single requirement except for the 4 that I've identified.
Which are listed there.
which are, they're not listed right here, but they are listed,
Sorry, I saw setbacks.
no, this is all, there's a lot of information here. So they're in yellow, those are the ones that aren't in yellow are the ones we comply with.
Right, so there's 3 setbacks, which was on the list.
Yeah, so there was a left side, and I've been combining the left side and both side, because they're interrelated. Like, we don't comply with both side, only because we don't comply with left side, and our right side is exactly in compliance. So it's, the left side, we're 3.4 off, both side, we're 3.4 off. Rear, we're 10 feet off, but that's only for a portion of it. In the loading area, we're off because we're required to have a loading area, but we don't have a loading area. So those are the only requirements we don't comply with. And, to the extent you're talking about density, bulk, we comply with all of those. We comply with all of those. This is a smaller project than we're permitted to have, significantly smaller project than we're permitted to have under the Dover Amendment. It's just for this particular design, we have no choice but to infringe on the setbacks, and we can't offer loading. Or if we did offer loading, it would mean we'd have to eliminate parking, which we don't think that makes sense. But let me get you I want to just quickly get to the loading requirement, because that is the last issue on the second prong of the Dover Amendment. So the gym project does not involve any cafeteria, and it does not contemplate any use that's going to require any deliveries. I think there is a loading area requirement for schools. It's like one loading area. I think that's probably in part because schools typically have cafeterias, but this building will not have one. And Mystic Valley already has delivery areas at 50 Laurel Street and the area behind St. Joseph's. So to the extent, and I don't think there's anticipated to be deliveries for the gym, but to the extent there were deliveries for the gym, they could be to those other locations that are they're part of Mystic Valley's complex. So compelling compliance with the loading area requirement, it would not advance any municipal objective. And it would really serve no purpose other than to, force Mystic Valley to design a larger project at prohibitive expense with less parking spaces and more significant setback encroachment. So that's basically my presentation. To sum it up, the building commissioner correctly found that the gym project is a protected Dover Amendment use, educational use. Mystic Valley cannot be required to go through a site plan approval process under the law, cannot be required to do that. The building commissioner should have applied the 2-prong Dover analysis that's set forth by the Supreme Court. And that 2-part analysis is, first, whether compelling conformity with the setback and loading requirements would detract from the usefulness of the project, which it would. The project can't go forward. It can't go forward if compliance is compelled. And would it appreciably advance Malden's legitimate concerns? And that's something I haven't come up with any way, we'll hear from others in the audience. I can't think of any reason why enforcing the particular setback and loading issues we're talking about here, in thwarting the gym project, I don't see how that would further any legitimate city purposes. We're asking for a determination that compelling conformity with the side yard setback and rear setback and the loading area requirements would detract from the usefulness of the project, and we think the facts are undisputed on that. And we're asking for a determination from this board that compelling conformity with the left side, both sides setback, rear yard setback, and loading area requirements would not appreciably advance Malden's legitimate concerns. So that's the end. Again, I appreciate your time. There is a lot. I think the issues are pretty straightforward. It's a 2-prong Dover Amendment test, but I don't think this is something that this board is familiar with, so I wanted to go in as much detail as I could.
Do you have a copy of that Campbell decision on film?
Yes. Does everybody want one? You know what, I have all these decisions. I have 3 decisions. I think it's 2 or 3 decisions.
Yeah, I can
So I'll just, is that okay?
Yes, thank you.
So if that wraps up your presentation, thank you for speeding through it too. I realize you.
May not felt like I was speeding through it, but
No, but I know you did. Nelson Miller was also going to do a presentation.
Okay.
And after that, we'll hear from the public and,
And again, we have the architect, we have the school, if people have questions, you
Okay.
know, if you people have questions, it's fine.
What's that? My laptop's not firing up. There we go.
did you hit that button that you plug into your
It
laptop?
just, my laptop was off, it just had to turn on
Oh, okay.
and go through A-Rod security to,
Yeah.
he promised me this would work, so.
I was standing there a couple weeks ago and it worked.
Oh, it worked.
Yeah.
All right. Good evening, Mr. Chairman, members of the board. Thanks for having me up here tonight. I know this is unusual. I don't usually get up here and make a presentation, but this is obviously an involved and complicated topic, so I thought just having a few slides put together would be a good idea. Some of these have already been covered, so I'll try to skip through that so you can get to public comment and into your discussion. So just to cover what we're doing here tonight, the administrative appeal, this is from our zoning ordinance. One of your powers, number 3, to hear and decide appeals of decisions made by the inspector of buildings. That's the old term for me, or other administrative official. And what decision was appealed? We've talked about this a little bit, mostly you, Mr. Chairman. The decision that is being appealed was my decision, which I provided to the charter school, to send them through a site plan review process for their proposed project, as opposed to their request upon me to make that decision upon myself. So that's really what my presentation is narrow to tonight. I'm not going to discuss setbacks and yards and what's equitable to the neighborhood and so on and so forth. It's going to be narrow to what is before you tonight. So just to go back to where this started, as has already been discussed, the presentation for this petition was made to me at the charter school by a group of people, some who are here tonight, September 17th. As you know, it's approximately a 6,500 square foot athletic facility. They did identify that there are some proposed violations of our dimensional controls, which you've already discussed tonight: left side setback, both side setback, rear setback, and loading space. Just to clarify a couple things, a both side setback and a left side setback is not the same thing. With a both side setback of 20 feet, you could actually comply on one side and not the other. So you could compensate for that violation on one side for what you don't have on the other. So they are actually distinctly different things, which you all have had before you in the past for variances for different types of projects. So when you get into our zoning, the question is, when you have a project and it has violations of dimensional controls, which within our zoning, educational uses are correctly allowed across the city, however, they have dimensional controls. how the use is regulated and how it's addressed through our zoning is in 12-12-20 under the exceptions. It says the use regulations of this ordinance shall is an important word when it comes to law. It means you have to do that, there's no option. Shall not prohibit, regulate, or restrict the use of land, buildings, or structures for religious purposes, for educational purposes. I'm not gonna read the rest of it. So that is in line with state law, that we cannot prohibit, regulate, restrict the use of lands, buildings, so forth, for educational uses, which is what we're talking about tonight. When we get into our intensity regulations, which is most often, regulations is a little messed up, which is most often called dimensional controls, we have dimensional controls for educational uses. And under 12-16-10, it states any building, structure, or part thereof converted, constructed, altered, or moved shall conform with the requirements of lot area, frontage, yards, usable open space, lot coverage, density, height, as herein set forth or as provided elsewhere in this ordinance. So that means any building that's going to be altered, built, modified, has to comply with the regulations in our zoning ordinance. So we have two things now that conflict each other. We have a use table, which allows educational uses, and then we have dimensional controls, which are required. You have to comply with those things. So this is where the Massachusetts Zoning Act comes in. Under the adoption portions of our zoning ordinance, 1232-010, it says this ordinance by its adoption shall, again, shall incorporate Mass General Laws, Chapter 48, as amended December 22nd, 1975, or as further amended. So what does that mean? That means that our zoning ordinance has to comply with Chapter 48 of the Massachusetts Zoning Act. And in reality, the Massachusetts State Zoning Act overrides our local zoning. So if something in our local zoning does not agree or comply with Chapter 48, Chapter 48 is what we are legally bound to follow, not what our zoning states. So where do I come into this? I'm really responsible for enforcing either. So I'm obviously the person in the city who's responsible for administering, interpreting, and enforcing our Chapter 12, which is our zoning ordinance, but at the same time, enforcing laws that are created under Chapter 48, which happens as of late more frequently than in the past, also enforcing those laws as state law, as the overriding zoning regulations for our city. So now we get to the Dover Amendment. You've already seen this tonight. Shall any such ordinance or bylaw prohibit, regulate, or restrict the use of land or structures for religious purposes or for educational purposes? And we're talking about educational use tonight. So this is the Dover Amendment, Chapter 48, Section 3. The second part, to further read into Section 3, it says, provided, however, that such land or structures may be subject to reasonable regulations concerning the bulk, height of structures, and determining yard sizes, lot area setbacks, open space, parking, and building coverage requirements. Catherine, to further answer your question from earlier, the nonconformities that we saw previously in my slide, as well as the charter school slides, their setback nonconformities, their parking nonconformities are specifically listed in there as setbacks and parking regulations. So those things are things that the Dover Amendment, 48, Section 3, says a municipality has the right to reasonably regulate. So who determines that? Reasonable regulation. I love the state tends to use words like reasonable. We could all debate what reasonable is, who's reasonable and who isn't. I'm sure everybody thinks that you as the Board of Appeal are very reasonable. But what Chapter 48, Section 3 does not do, anywhere within it, is state specifically which municipal board, commission, officer, or employee is charged with this determination. Everything you've heard so far that states that I have the authority to do it has come through case law. It has not come directly from Chapter 48, Section 3, stating that the building commissioner, the inspector of buildings, the zoning enforcement officer is the person responsible for determining what a reasonable regulation is. So let's talk about entitlement processes a little bit, because I think there's some confusion as to how these processes work. Special permits can vary a little bit from town to town, not a lot, or the way they're performed can vary a little bit. In the city of Malden, we essentially have two ways of special permits issued. One is through the planning board, one's through the city council. There are a couple of things that the city council does. Most of them are through the planning board. A special permit is a thing that can be denied. You go for a special permit, you might get it, you might not. So a special permit would not be an acceptable process for a Dover Amendment protected use, because that use could go into that process and end up with a denial, which is not allowed by state law. A variance you're all familiar with. It's a much higher standard than a special permit. It's specifically stated by state law what criteria, and I'm telling you all this, which you all know, but this is more for the audience. There's specific criteria you have to hit, and most of the time you shouldn't get a variance. A variance is not appropriate for a Dover Amendment use because a variance can get denied. While I'm on the variance thing, let's talk about MC a little bit, because obviously I was very involved in that project. As all projects in the city, specifically large projects, I do my best to meet with property owners and contractors and project managers prior to large projects to make sure that their entitlement process is in place. It was the reason for the meeting I had with the charter school. Malden Catholic decided to go through a variance process. The Dover Amendment doesn't allow me to force them to go through one, but it doesn't stop them from voluntarily doing it. I think it's slightly irresponsible to state that Malden Catholic knew they were getting a variance going into it. I don't know how they would know that. I certainly wouldn't tell them that. I don't get to vote on variances, and I know none of you did. So I would say that I don't think they knew anything, but they felt like they wanted to go through that process, and there are some advantages to building a building under a variance as opposed to depending on a state law that can change. For the most part, down the road, a variance protects you in perpetuity, a state law doesn't. State laws change. So getting back to variances, that would not be an appropriate process for a Dover Amendment use, and no Dover Amendment use should ever be required to get one. Site plan review is a process where you cannot be denied. There is no denial of a site plan review. Site plan review is a process that is provided for a project to go in front of a group of people decided by the city. Most often, people who have some kind of investment, either in the community or in that neighborhood. And it turns into a collaborative process between the city and the property owner, and a project comes out the other end of it. So site plan review of those three is the only one where you go into it not capable of being denied. So some case law was provided by the charter school, which you all saw tonight, Campbell versus City Council of Lynn. This was from 1993. Real quick summary on that. This case said that the zoning officer does have the authority to make the determination of reasonable requirements. You also saw our case from 2009, Bay Farm Montessori Academy, town of Duxbury. They used a little stronger language, saying the zoning officer is charged with making determinations. The Dover Amendment is probably one of the most contentious and litigated pieces of zoning that the state has. It's been around since about 1950. You can read case law all day long on the Dover Amendment. And for the most part, when it comes to case law, you know, what's kind of latest is greatest. There's a case in 2010, Jewish Cemetery Association of Mass versus the Board of Appeals of Wayland. Again, to summarize a very long summary, the case stated that in light of the above, I find the uses protected by the Dover Amendment may be subject to site plan review, as long as such review is limited to reasonable regulations. So we've already discussed what the reasonable regulations are. It goes on to say, in its analysis, the appeals court noted that there is nothing in the language of 48 Section 3 which contemplates the requirement of site plans and informational statements as monitoring devices for educational uses. However, it does not follow, meaning the court, that the absence of an express reference to site plan review in the Dover Amendment automatically results in an unreasonable regulation. In fact, the site plan review process implies regulation of a use rather than its prohibition. So that reinforces the idea that the site plan review process is a regulation of a use and not the possibility of it being denied or prohibited. There are other cities and towns in the state that use site plan review for Dover Amendment uses. Some of these have been challenged, some have not. Concord, Framingham, Wayland, Brookline, Somerville, Newton. You'll see that all these cities and towns have site plan review, and a lot of the language in it is very similar, where it speaks to the specific things listed in Chapter 48, Section 3, as well as my letter to the charter school, as to what the review of those projects can be, narrow to what is allowed by the Dover Amendment. To get more recent, we have ADU law. So I'm sure some of you may have heard about the Affordable Homes Act, which just came into place this year. The act actually modified Chapter 48, Section 3, and it includes accessory dwelling units as a protected use, similar to educational, religious, daycare, agricultural, and so on. So 7A CMR 71.00, this is about to be law, February 2nd, I believe. Within that law, there's a definition for site plan review. A clear and objective process established by a local ordinance or bylaw by which a municipal board or authority may review and impose reasonable terms and conditions on the appearance and layout of a proposed use, land or structures prior to the issuance of a building permit. So it's not quite as detailed as the requirements within Chapter 48, but it's clearly the same objective. So it does list within that law unreasonable regulations. It creates a list of them. And the fifth one is, what's unreasonable? It says site plan review. It says any requirement under site plan review concerning the protected use ADU that is more restricted than those applied to the principal dwelling. It doesn't say you can't do site plan review. It says you can't have a requirement under site plan review, which is more restrictive. That therefore says you can perform site plan review, and that has been backed up by meetings that we as a city have had with the EOHLC, the Executive Office of Housing and Livable Communities, which put these regulations together and have done their best to provide us with guidance as to how to enforce them. So the newest addition to the Dover Amendment list of uses is, it has the possibility of site plan review. So finally, to wrap this up, my decision. This is from my letter that I sent to the charter school on October 23rd. Just to remind you again, what I was asked for was a zoning determination relative to their request that I make the determination that their proposal was the violations within their proposal were reasonable, and that I could just move forward with issuing a building permit. The response I gave to them is I've determined that in the absence of a review process within Title 12 of the City of Malden ordinances, which specifically addresses 48 Section 3, by providing reasonable regulations regarding the bulk and height of structures, lot sizes, yard areas, setbacks, open space, parking, and building coverage requirements, a site plan committee should review the proposed design in accordance with and narrow to these reasonable regulations. So the direction was that a site plan review committee would review the project. They would review it solely for those specific conditions. There will be nothing added to that. We do have site plan review process within the city. As was mentioned, we have two. One is the Rose Quarry, which deals with a very, very specific set of regulations for a very, very specific area of the city. We have a site plan review process for RIO.
For what, I'm sorry?
RIO, the Residential Incentive Overlay Districts. And that is a more over-encompassing kind of site plan review committee that looks at our zoning in its entirety. Either way, that group would have been directed by me to review the proposal under these specific criteria.
Is there any site plan review specifically for this district? I mean, I guess I'm struggling to understand where it comes from in this area. I mean, it sounds like it's your opinion there should be a site plan review, but does the ordinance speak about a site plan review for this specific circumstance?
No, the ordinance is silent as far as how Dover Amendment uses are treated. So in the absence of the zoning ordinance having some clear direction, I default to the state zoning act.
But you gave two examples where site plan review, but those are the only two circumstances where our ordinance requires a site plan review?
Yes, we don't use site plan review a lot in the city at all. Most things are either allowed by right, denied as a no, not allowed at all, or a special permit.
And how does the site plan review, how is it set up? How are members selected, and what would be the process for
The,
getting it?
the ordinance for each specifies what the makeup is. There are a couple positions that are appointees, so you
Yeah.
don't exactly know who they're going to be. But, for instance, an appointee by the mayor or by the city council, so.
I think it speaks about how often we hear about site plan review in Malden. It's not, I've never heard of it. I didn't even know it existed in our city.
Yeah, all of the Rose Quarry development has been permitted through site plan review.
Yeah.
And the last things, other than Rose Quarry to be site plan review, would be areas right down here in the downtown, which fall under the RIO overlay district.
And you mentioned that there were, what is it, six towns, cities and towns that have site plan review for Dover Amendment.
Yes.
Do they have that? Do they have language in their ordinance that says they gotta go there? Or that that's the avenue they take?
Yes. So they,
But the
obviously,
city-
they're all different,
But
every
the
city.
city doesn't. Our city does not have that.
It does not. So our city has, to use educational uses as an example, there's
But
three
what he's-
areas,
But what he said was that the Dover Amendment says that site plan, they don't have to go to that if it's not specified in the city. He's shaking his head, yes, but of course he would. But I mean, it would seem that every once in a while we come across a gap in Malden zoning ordinances that the city council and the planning board hasn't thought about. I mean, because they hardly use
Yeah.
it. I mean, I'm wondering if this is one of those spots where.
there's certain,
I'm not saying you did something wrong, I'm just saying is that the city hasn't addressed it to give you that authority to make them do something extra.
there is a gap, clearly. And
I think that is the point of this
that's
meeting,
why we're here tonight. So,
is that he doesn't,
But
Have
we
the
can't
authority
correct,
to
we
make
can't
that.
correct the gap. I
No.
mean, it's there, and the state has said seemingly that we keep this, the state loves making, the stuff like making broad ordinances that, sound restrictive and then say, but these people don't have to do that, They carve out sections of, where there's.
I think it's the other way around. The state is more general and they leave it up to the cities and towns
No,
to.
the state goes, if it's well, like this, I mean, they're saying it's an educational facility, boom, there's nothing you can do. If it's a halfway house, there's nothing you can do. If it's a drug treatment center, these city ordinances really can't affect too much. I mean, it's very difficult. So they carve these things out. I mean, and the fact is that the city has to, if they want to make it more restrictive, they've got to do it by ordinance. I mean, and they're kind of putting us on the spot. But they can't.
The question tonight is though, the city ordinance doesn't give Nelson the authority to make this decision one way or another.
Well, no one answers the question. I think the question is, does it go to site plan review, or is Nelson the one who makes that decision?
Right.
And I think council addressed it. It sounds to me the Campbell decision kind of resolves that. It kind of says that it's the building commissioner. Can you speak to that? Because that's how I read it.
For us.
That's how I read it. It sounds to me that's really saying that the building commissioner is supposed to be making that call, which is then an appealable decision to us.
is that the 1993 decision?
Yeah, the Campbell
Yeah,
decision.
so my contention would be there's been dozens of cases since 1993, and as you are aware, case law changes, and case law changes how things work.
But has that holding changed? Has there been any holding that said that it's not up to the building commissioner to make that call? I understand if the town selects site plan review, Malden hasn't done that. So it seems to me Campbell is the precedent that says that it's really your purview to make that call. I mean, are you aware of anything? I know you're not an attorney, but you know this better than I do. Is there anything that's kind of changed that holding, or?
Well, I would argue that the case that I presented states that you can apply a site plan review process to a Dover Amendment use. So where our zoning does not say that I need to make that decision, and it does not say that there's a site plan review process, then that allows me to revert to Mass General Law, Chapter 48, and anything allowable under it, which means I can either, I guess, decide to do it myself, or I can say, no, this should go to a site plan review process. In my opinion, a Dover Amendment use, which is going to get approved, but has some sort of violation attached to it, is better to be reviewed by a site plan review committee made up of the people who live in the neighborhood, who are city officials, who are public safety officials. It's better made by them than it is by me, whereas my job, which was recently described very well by Councilor Winslow, I call balls and strikes, and everybody else makes the strike zone. So I don't think that it's really the best thing for the city, for me, to unilaterally make decisions, or, for lack of a better term, pick winners and losers through the stroke of a pen, as opposed to an allowable site plan review process through state law, where the city can then engage the property owner and come out the other side with a project that works for everybody.
But I think we come down to the problem of the city doesn't have an actual course. I mean, your choice, the city has left you with a choice of, I approve this, or I don't. And if you don't, then he's here anyway, because he needs a variance or three. I
Yeah.
mean,
The city's
but
left,
I don't know if you have the right to make the course. The city hasn't chosen the course, and then they're asking you now to make the course. And that, I don't think, is the way to do it. You're, at this point, they don't give you 3 options or 4 options, they give you 2, yes or no. I mean, it seems like, according to what the ordinance is, and that you just, that's your choices. I mean, ball or strike. I mean, 3 and he's out, and, 4 and he goes with it, but I mean.
and I would argue that if I were to perform a literal enforcement of our zoning ordinance, as it's constructed, I would be required to send them for a variance for violations of setbacks and rear yard.
Yeah.
Now, going back to my presentation, I also need to enforce state law, and I can't send them for a variance for that. So our zoning ordinance has not said anywhere that the building commissioner is responsible for making that determination, and it's not stated that a site plan review process is the group that would make that determination. So
So do they do, does that issue with the state and the local laws? I mean, now it seems like it's only giving you one choice. Well, what the heck, I don't have another choice, I've gotta give it to you. Why isn't that the only choice you have,
I'm not
You
sure I
can't
understand the
say-
question.
Well, you say you can't say no, because you can't send them for a variance. But the state says you can't do that.
Right, so they can be held to reasonable requirements. So now the crux of the matter is, who determines that? Is it me, or is it a
Well,
lawful,
in
or is it
Malden,
a?
it appears that the only one would be us, because they haven't,
It would be us
but
through a
they-
variance, but
No,
that's not what they're here
variance,
for.
No.
well, the site plan, they don't have that.
They do.
Site plan review can't
Yeah,
deny
A site,
them.
a site plan review process, the project does not need to come out the other end of it in strict conformance with setbacks, yards, parking.
But
They
haven't given
don't
you-
need to do that.
But they haven't given you that choice at this point. it sounds
Correct,
like.
there's nothing in
They
the
haven't given me
ordinance that
either
gives them the
choice,
authority
so
to
I
make
chose
that
one.
decision.
Yeah.
Correct.
And I don't blame you, and I like your proposal, I think it would be the best for the city, I just don't think you can create a site plan review on your own if the ordinance doesn't speak to that. That's my 5 cents.
Yeah, I mean, that's, basically what I'm saying is that you can't decide,
Someone has to decide,
well, I know, but he can decide yes or no.
yeah,
Can I do this project? No.
but that's also
And then
appealable.
it's up to them to go
then they would be going for a variance.
No, they would be doing an appeal of his decision.
Oh, right,
It
which is
goes
what
to
they're
him.
doing right now.
He decides if Dover applies, if they don't like it, they appeal it to us, and if we don't get an appeal there, then they go to land court or Superior Court. So I think that would be the path of trajectory. So I think there's kind of it seems to me there's three decisions. Send it to site plan review, send it back to Nelson and tell him to review it per Campbell, or make the decision for Nelson and apply the Dover, to say that a Dover applies.
But tonight, we just need to
Well, we could
decide whether or not he
What he's
was,
saying is we could say that the decision is not correct, or is, according to state law. And, and the Dover amendment applies, and therefore, we send it back and say, based on that case, that he should decide that they would proceed. He makes a decision. No or no vote, and then they.
You all set with me?
I think so.
Nelson, thank you very much for
Yes,
your
thank you.
presentation.
I mean, there's no straight line here.
No, there isn't.
I mean,
So, there is one letter that was submitted in support of Mystic Valley. And there are two letters that were submitted in favor of, Commissioner Nelson's decision. I'm not gonna read those, but we will have them included in the minutes so they can be viewed online, when they're made available. Is there anybody here, from the public that would like to speak in opposition of Nelson's decision?
not on the project as a whole.
Right, just on the decision. I'm not seeing anybody that would speak. Just state your name and address and.
Yes, my name is Neil Kinnan. I live at 11 Spruce Street, Malden, Mass. In full disclosure, I currently also work for Mystic Valley. I was a founding board member in 1997, actually 98 we opened. And I am here to speak against Commissioner Miller's decision. And it's based on having been a former city councilor as well for 10 years, representing the ward that this school and this building is in. I had a lot to say. I had read it down, but I heard you loud and clear. What is clear to me as a former city councilor and board member King has brought out, and I think, and I'm sorry I don't know your name, the gentleman over here.
Sherwin.
Sherwin?
Yeah.
Is in my entire time, and I've been involved in city government until I left the council for many, many years, even before those 10 years, I have never seen somebody come before any board and a building commissioner make a ruling that somebody has to go to something that isn't already an ordinance. This would set one heck of a bad precedent in this city. As somebody who represented people coming beforehand, opposed and for, where they said, the building commissioner came up here and said, well, I don't want to be in the vice grips here, so I'm going to deny this under a ordinance which does not exist. There is no site plan. And here's a point I want to make to all of you. It was said that, somebody said, they should have done this before. And that is true. This was contemplated before. This was contemplated in 2021 by the very same counselor who put that ordinance on the city council docket 2 days after our meeting to make site plan review 2 days after our meeting with Nelson Miller, and readily admitted he had talked to Nelson Miller about doing site plan review in 2021. And that effort ended at the end of 2021 or early 2022. Remarkably, sometime around that time, Malden Catholic announced their project. I don't want to connect those dots, but I wasn't born yesterday. And I can say this is the first time, and maybe you can look into this with the solicitor, that a building commissioner has ever come forward and said, I want them to go to site plan review, and you, or your board, whoever it was in the past, said, well, there is no site plan review. There is no ordinance that says this. Well, I want one created. That's what he said tonight. I want one created so I can send it to them. That is completely political. Now, you can readily admit, I wish there was one. I wish they had this, but they don't. So I think I agree with what I've heard up here, particularly from Mr. King, is you have two choices. You can send it back to Mr. Miller and say, look, there is no site plan review, you need to make a ruling. Then he can make a ruling, if that's what you want, and that ruling would come back to you still to make a decision. It's not a variance, it's relief. And that relief then would be based upon a number of things. And I want you to think about this very, very hard, because you don't want to be put in a political vice. And I've watched this committee, you existing, and other ones before you, very unpolitical. But if you're put forward to make a decision, it's got to, and that we call it reasonable. It's what reasonable people would think. And some of us have been here for a long time, and we watched all these schools be built. They were new 25 years ago. And I can take you, and Nelson, I've shown him this, I can take you to almost every single one of them and show you setback issues, loading issues, parking issues on almost every single one of our schools, which is far more egregious than this project in front of you tonight. Far more egregious. And then we can walk down the street to Malden Catholic. Remember, I live in this neighborhood. I love Malden Catholic. I'm a Malden High graduate. My father was a Malden High graduate. My family's lived in this community and Maplewood for over 100 years. I live in this zone. I got one of the notices. So I know these people here who may not like the project. I worked with the school. One of my jobs is to work with the school to try to get things through. I worked desperately to help them make a project that would fit, not bring more students to Maplewood, because I understand all schools are challenged today. Not bring more students, we did that. Make it under the heights of many of the houses. Make it the setback from the houses compliant with all zoning, and do the best we could. And that's what we did. And Mr. Miller even said it was a reasonable plan, as did Councilor Winslow, who 2 days before he put his paper in told me off the bike path that, oh, I saw the plan of Mystic Valley. It's a good gym plan. And then we saw this start. I don't know what to make of it, but I do know what your job is. And I don't want you to be embarrassed later, because what's reasonable for others is certainly reasonable for Mystic Valley. And when Malden Catholic, right down the street, built a 45-foot building, and we're building a 24 or 29-foot building, when Malden Catholic gets a 52 parking space variance to do off-site parking, and we're asking for none. And just at the same time last year, and you may or may not know about this, but Mr. Miller Mystic Valley requested to use its parking in Maplewood Square, which is a separate lot adjacent to the bank building, that the fire department had helped us with tearing down and working on while they parked there and other people parked there. Mr. Miller sent us a letter saying, no, you can't park there. That's off-site parking, and that's not allowed by the city ordinance. I cited Dover to him personally. And then I cited the fact that I don't get this. We're being treated entirely different. I'm trying to relieve the neighborhood of teachers parking on the street, and we've got this large parking lot that we need to use. I put 20 feet of grass in so we comply with the grass. You're not allowed to do off-site parking. I said, Malden Catholic just did off-site parking. How'd that happen? Well, they applied for a variance. I said, Dover doesn't need you to do that. This is a reasonable request. We hired these lawyers, same people. Sent Mr. Miller a letter. 2 days later, he called and he said, send me the parking plan and I'll approve it. Did he come to you? He did not come to you. So how is it that he was able to approve that, which is not, that he was right. It says no off-site parking in the city ordinances will be allowed. And yet he came forward, and 2 days later, and a few weeks later after he saw the plan, he approved a permit for us having off-site parking without you. I'll end it there. But all this, you've got to determine what is reasonable. Is this school being treated reasonably as every other school? And I would tell you right now, that is very clear it's not. And the planning board last week, your city planner said, we are not. We are exempt in this site and the other Maplewood site today from site plan review that the city council tried to ram through and didn't follow the city ordinances, which said if they get their thing in before a public hearing is announced, it doesn't count. So they sent it back to the city council to make that change. Thank you very much.
Thank you.
Good evening. My name is Rick Vayu. I'm the Assistant Superintendent of Mystic Valley Charter School. I've been with the school for 20 years. I oversee finance and operations. We purchased 31 Granite Street, and probably a few days later, Councilor Winslow came to meet with myself and our board chair. And you know, one of the key takeaways for me during that meeting was him saying, well, we don't need the charter school anymore. And this came from, you know, many interactions we've had over the years through our purchase of property in Maplewood Square. So the fact to go through a site plan review with somebody who would make the appointment saying that, you know, we don't need the charter school anymore, that's a pretty political process that I'm not comfortable taking. And so, you know, we hired attorneys to protect our rights. As Mr. Kinnan said, last week I attended the planning board meeting. And so we met with Nelson in September to review our plan, said it was a good plan. And within days after that, Councilor Winslow submitted a site review plan that had, you know, all these conditions in it and who the political appointments would be. And you know, we worked with our attorneys to come up with a plan that said, you know, reinforce that we're exempt from site plan review. And at last week's planning board meeting, the planning board indicated that that's the case. We are exempt from any site plan review proposal that was submitted. And the proposal that was submitted had a lot of issues that were raised by the planning board, and it's back at, you know, back to the city council to address. So in Nelson Miller's denial for us for this project, he specifically referenced site plan review that didn't exist at the time. So as a person trying to, you know, be responsible, you know, I'm responsible to the school. And I just see the inconsistencies that we've dealt with as we've purchased property. You know, we have many Malden residents who attend our school. We have a lottery coming up in January, and we have over 500 applications from Malden residents to attend our school. So all we ask is to be treated consistently with the other schools. And, you know, I love the fact that you said, you know, this isn't a political body. That's what I'm hoping for. And you mentioned that this is an atypical case. You know, I think many of us who have spoken already have said, I don't think it's atypical because Malden Catholic got some significant controls that were approved. And what we're asking for is very reasonable, and that's what's covered under the Dover Amendment. Thank you.
Thanks, Rick. Is there anyone that would like to speak in favor of Nelson's decision?
Yes, Ward 6 Councilor Steve Winslow. I live at 83 Jacob Street. So first of all, I want to dispel this idea of this being political. I did not get any contact with Mr. Miller until after the decision was issued. So the, as Mr. King pointed out, this just showed the gap. So, so that's one of the things, and I really dispute anything related to Malden Catholic. I was not involved or ever involved. I did not come before this board for the variances. So if it was political, why didn't I come out more in advance on that? So I was not involved in that process. So the vice that is here and who is driving that vice are the people from the Mystic Valley. The people, you see all these people in the audience, you usually don't have this many people here. This is the neighborhood that is sick of being in the vice of Mystic Valley. So that's why I'm here, and that's really what I want to talk about. So I am here to speak in support of and ask the ZBA to uphold the building commissioner's decision to have Mystic Valley go through a site plan review process. I know several times I have been before this board and spoken in favor of projects that there was actually a lot of community support for. And this board, just like Nelson Miller, said its role is not to change the strike zone, it's just to call balls and strikes. And so that was really, even with projects that had support and had, you know, variances of this time, you knew that it's really the city council's role to craft the height setbacks and other, you know, intensity controls. And you didn't see it in those situations to make that relief happen. So yeah, Mr. Kinnan is right that in 2021 and 2022, we undertook specifically looking at how our ordinances, you know, meet the state law. So we looked at it in depth. So we had, we presented that to the public. We had an ordinance that actually did include a site plan review process. We had input from our city planner, Michelle Ramiro, and our legal department. One of the things that particularly Ms. Ramiro pointed out was the requirements that that Dover Amendment does allow us to establish. So what we worked out was a focus specifically on the intensity controls, such as setbacks, open space requirements, and all that. And through that review, we determined that we needed to do some update on the open space requirements. But out of respect to the concern about equal treatment, the other type of intensity use things, setbacks, building heights, all those things were really left unchanged through that process. So the Mystic Valley at one point is saying we're being treated unequally, but when the city has made an effort to set clear, consistently to be applied rules, they have come up with a project that doesn't do that. And Mr. Valou mentioned about that, you know, the 31 Grand Street. They knew, and they've been looking and salivating over this property for years. So 2 years ago, 3 years ago, they would have known that this would have happened. So that's one of the things that they were aware at that time. These were the type of dimensional controls that we were going to apply. So, so we had gone through that process, and the decision at that point was to focus on setting clear dimensional controls in a fair and open process. And that happened. Mystic Valley could have made any comments to ask for changes to accommodate this property that they had very much intended to purchase. That did not happen. So now they're trying to come through another process and put this pressure on the building inspector. So that's just the type of thing. And really what this hearing is pointing out the conundrum of, the Dover Amendment in Chapter 40A, Section 3. Well, at one point it's saying we can't limit educational uses, but we can create reasonable regulations. That's what we did in 2021 and 2022. So that's really what should be applied. In this instance, the city has made a determined effort to craft reasonable regulations that create those clear controls while not prohibiting an educational use or on a former residential property. Remember that. The applicant submitted a proposal that does not conform, and it has to ask the building inspector for relief. The building inspector did not deny that relief. He offered an avenue to consider the necessary relief. And as I've indicated, I'm not here, I already, well before this, indicated to Mr. Kinnon and even Mr. Warren, who's on the trustees, that I'm open-minded about this. But you can see we have a lot of residents who don't feel that, as the attorney said, these things might be minor and slight. I mean, it's a lot different to have an institutional use right next to your house than it is to have a neighbor, a pleasant little old lady. That's the type of thing. This neighborhood is substantially impacted by hundreds of students and their parents coming here. So you can understand the sensitivity. And I think in this case, that is something in the reasonableness. That is the type of thing to say. We have set reasonable controls that we should be more cautious about varying those things and not looking at, it's a lot different to, I live in the neighborhood too. I live, just up the street on Jacob Street. We have setbacks. I mean, we have close proximity. It's part of living in an older city. But we have, it's a lot different living next to, quiet neighbors or people who have lived next to it for 20 years than it is hundreds of students. So I think it is the type of thing that, I think it is, I do support that. I mean, like I say, the reason that I reinitiated and reintroduced that site plan review because, as Mr. King pointed out, the gap. We are trying to make it clear, and we are listening to Mystic Valley about the concerns and trying to, I do respect that this board has been non-political, and we are, considering that at the council level, but we have this challenge now. We have a project right now, and I think what you see, that one of the things you talk about, what Mystic Valley is concerned is about setting a precedent that actually makes them required to sit and hear the comments, and it's great that the neighbors here to make those comments about the impact their efforts are making, and to make sure that they're reasonable things that happen. I hear the type of thing, I mean, to suddenly, if you go by Mystic Valley at night, their buildings are lit up like, very, very bright. So suddenly, instead of having a quiet neighbor who turns their lights off at night, you're next to this institutional lighting. You have the type of thing, it looks like the building is orientated towards Granite Street. I mean, you heard one reason why they want to get exempt from the loading requirement is because their loading gets, done on the St. Joseph's lot, which they have a lease on. So why is the entrance orientated to Granite Street? Wouldn't it be less impactful on the neighborhood and a reasonable thing to have it redirected there? And say that the purpose of some of these setbacks is to allow some distance. So, you're gonna have cars, you used to have, not a lot of traffic. Suddenly you're gonna have every morning, at least 7 teachers or administrators pull up in your backyard as they're screening. So that's the type of thing. We understand that educational use is something that is generally allowable. And I do think that this project, even if you look at applying a couple things, the Duxbury case. I don't know if you noticed, the Duxbury Site Plan Review Committee was the town meeting. I mean, that is politically absurd. So that's really, really out of whack. to expect that. So, whether that precedent really applies in what this instance, and certainly it's a different situation. So I do say that. I mean, so, a couple other things in terms of looking at, the two-pronged tests. So in terms of the educational need for this big of building, I played basketball in elementary school. I had to change my jump shot because the ceiling wasn't high enough. A lot of different things that you heard that the school is admitting. This is not intended to be a competitive gymnasium. This is a space for kids to get some activity. You can throw a couple hoops. You don't have to build a regulation court. So they can meet their educational mission by reducing the width of the building 4 feet. So that's the type of thing. So they're asserting that, but what they're saying is that the educational mission is to have a place for kids to play indoor years round. And actually, I see that's a benefit. I do. That one reason why I think this can help is the fact that they have essentially taken over Trafton Park to use as their outdoor gym. And I think that's funny in the phrasing their attorney said, that there's this need to use Trafton Park. Well, we have a permit requirement, and they have refused to come in for permits here. So that's the type of thing. If we're giving them some relief because they're building a building, maybe that should be part of the building permit to say that you have to get a permit to use Trafton Park to help relieve the burden that is placed there. And that is not a Dover Remented thing. That's city property that they use. And they're refusing to even comply with our reasonable regulations there. So that's the
Would
type
that
of
be up
things.
to the department that is in charge of those?
The rec department, we have asked, 2 years ago, neighbors were coming to me to ask about that. We have updated our requirements to make it clear that big users of our parks need to come in for permits. And the city council even made sure that there was a reasonable way that could happen with the collaboration of a user. They have refused to even come in for the application. I'm open to that again, but it's the type of thing. One reason why I expressed the interest of this.
I feel like, and I hate,
Okay.
I'm sorry,
But okay, so.
trying to
but
cut
coming
you
down-
off, but
coming
let's
down to
focus on
this, Focusing on this.
not
that-
attacking and
So, but
working on the
I do think,
decision.
so let's come back to this, is that I think it is, we have this conundrum that is presented in the law and that the building inspector has, raised, that we're put in a situation where the law both says we're prohibited from, we can't deny an educational use, but we can put reasonable regulations. The city council, back in 21 and 2022, created reasonable regulations. And an institutional use, like a school, has a big impact on a residential neighborhood, and you will hear from the neighbors to that. And so we should not be so cavalier about waiving those. So that's the type of thing that we should not be cavalier. And I think that the thing you also hear about the test that is being asked to apply. Nelson Miller is not an attorney. And there's a lot of facts about that, of what are the burdens on the municipal side? Is that really an educational need? Those are the type of things that, it's hard to have one person make that decision. So one reason why we are working on a site plan review for other uses that we can't send to, for a variance or aren't subject to site plan review is this kind of conundrum. We need to have a process considering these so that it can be not just one person, that we have some expertise of people who help determine relief. And then we also need to have a process that the community can give impact to understand. We have setbacks because there's a need to make sure there's not friction between owners. There's the public safety issue to make sure the fire department can get in there and that type of thing. The reasons, you go back to why their zoning was that so that buildings on our top over, that the density and conflicts that come when buildings are too close. So that's really the type of thing. So the city council did its due diligence back in 2001, 2002. Those requirements I believe to be reasonable, and that especially in this instance, and as you'll hear from the people, they want to have some voice and shape this. It's not to say we would, I tell everybody as I speak to them, the Dover Amendment says we can't deny an educational use. We can't make them to build a house back there again. If they're determined to do an educational use that complies with the reasonable requirements that we made an effort to do. We looked at all our schoolyards and stuff like that. We set our standard for open space based on what the typical schoolyards. We made that due diligence, and now they are not, they bought a property knowing it was subject to that, and now we're asking someone to make up for that thing that they knowingly did. So I think that's unfair to our building inspector, and if they want to do what Malden Catholic did, or wait till we have that ordinance done, that's what they should do. But otherwise, I think that's, you know, that's where I'm at, so.
In your opinion, if I could just ask one question, does the ordinance allow for Nelson to make this decision either way?
You know, I think the challenge is that, often there's cases in law where, you know, you write laws or regulations. I think what Nelson's is saying, it's really under, it's not under ordinances, it's under Chapter 40A, Section 3. He has responsibilities also under state law. He's saying that I can't send it for a variance, it's not subject to site plan review. So he's just proposing something. He could just say, you could send it back saying, Nelson, you know, review this with a team of people. That would be, I don't think that would be a variance. And so Nelson's saying the team of people I'm gonna use is under this ordinance. That can comply both ways. It doesn't necessarily be under the section. He's just reaching for an example. And that is the type of thing that, you know, we're looking at. But, you know, like I say, I think personally, you know, it's the type of thing that, you know, maybe that's the type of thing to send it back to Nelson to say pick a, you know, a non-biased group of people to review it. That would be the type of thing. But I think it is, you know, that is another choice to send it back. And what I'm calling for is to make sure that the community can get its input on what these impacts are, and to make sure that the community knows who's making the decision and how they're doing it. That's really what it's at. Not to have it be on one individual. The charter school loves trying to cut sidewalks. And when Mr. Velo, he took my one statement out of context about what I mentioned about the kind of political context the Mystic Valley Charter School
I think
is.
it's value.
What?
Value, right? Is that how you pronounce it?
So I say, like, you know, as Mr. Kinnan said, you know, great job, 1997. I give him credit. It's a lot what's done here. This is a very successful school. But that was 25 years ago. The school has maxed out in terms of how many Malden students can have under the law. And I basically explained Malden public schools are doing better than they did in 1997. So there's no real, the charter school had hoped that we would trip and fall and they would get.
Sorry, I feel like we're really going off track now.
well, so
I feel like we've talked about the same issue repeatedly.
I'm just responding to some specific things. So I just want to say that that was taken out of context, that I'm just saying that the political context has changed in terms of for 25 years, the charter school was in the habit of getting everything it wanted out of the city. And now it's not that we're saying that the neighborhood is dead set against this project, but we want to have a, you know, make sure that whatever decision is made, we know who's making it, that there's public input on it, and that's it. That's really what we're talking about, is really about making sure these folks who all spend their, you know, week before Christmas out here being concerned about their community get to have input. That would be a great Christmas present for them. Thank you very much. Great.
Thank you.
Thank you.
Mr. Chairman, I just like listening to Mr. Winslow. No, not a question. No, just on one of the statements, I think that was very telling is him saying, we need a process. That's what we're saying. We need a process. We don't have a process now.
That's what I'm seeing too. So I don't feel that,
It has.
and we haven't heard from anybody
The
in
only-
favor
the
yet,
only-
but I don't feel that he had the mechanism available to him to make this decision
Other
one way or
than-
another.
Other than yes or no. That's,
Right.
he always can fall back on yes or no.
It's just not there. That's
But
an
I
ordinance
wanna-
issue.
I want to be clear, we're not here to hear about the effects of the charter school on the neighborhood. We're here to just, if somebody has
decision.
have an opinion on that decision, and under what part of the state law that it was correct, I mean, we can listen to that, but I mean, the fact that they keep the lights on late at night, I mean,
That's not what we're here for.
No, that's not what we're here. I mean,
Would anybody like to speak in favor specifically to Commissioner Miller's decision? Let's not go into this person's bad and that person's good or anything like that. Just whether or not
I
he
got
had
you.
the mechanism to make this decision available to him.
Yes. Hello, I'm Karen Cologne Hayes. I'm a city councilor at large here in Malden. I'm here to speak in favor of Mr. Nelson's decision.
Mr. Miller.
Thank you. Our building inspector made an excellent case for sending this project to a site plan review process. As he stated, the site plan review is what would be the best-case scenario for everyone involved. It sounds like the only choice that would have a definite positive outcome for all. As he mentioned, it can't be denied. Because this hasn't happened before, I understand that might be the first time you're seeing this, but it means just that. It's the first time you're seeing it. That happens a lot. There are first times for everything. So now we're here. Maybe it should have been done years ago to come up with this process, but it hasn't, and we're here now. And I think that Mr. Nelson, our building inspector, has the right idea, and he really came up with something that would help everyone have public input, and I support it and think we should move forward. Thank you very much.
Thank you. Would anybody else like to speak in favor? Come on up. Oh. And just as a reminder, because I want to speed this up, only on the decision, not whether or not you like them as neighbors or anything like that, or their
Can you hear me
lights.
okay? All right, my name is Mary Lavoy. I live at 100 Olive Ave. Okay, I didn't come prepared. I have no notes. I just listened, and I said, I live, my home is in the neighborhood. It's a neighborhood, okay? My family, we go to Troughton. We go to Park, we do that. I drive down that area every day. I go by 31 Granite Street. I do drive that car. And I'm telling you, it's bad. The area is bad. The traffic is terrible.
So just as a reminder, we're not here to decide whether or not they can build the building. We're here to decide whether or not Commissioner Nelson's decision was,
Okay.
Commissioner Miller, I'm
Okay.
sorry, whether or not his decision was right or wrong, or do we agree with it or not agree with it?
all I
So we're
know
not
is
approving the
that
building
We don't
tonight.
need no activity in that
Okay.
area, okay? I understand that a gymnasium is very important to the school, but there's other areas that Mystic Valley, they have other buildings they could put their gymnasium in, okay? The traffic in that area is bad. I just want to protect my neighborhood. Over 30 years in Malden. And I would just like to say, respect the neighborhood and the people that are here also.
Thank you.
Okay, thank you.
I'm gonna call him Commissioner Nelson forever now.
Hi, thank you for your time. My name is Vincent Gigante. I live at 26 Jacob Street. I'm one of the property owners that abuts the property, and I don't want a gym in my backyard. I know that this gentleman here said it's not public opinion. Right now, you can't voice your opinion. You can just say if you approve with what he said. Is that correct?
That's correct. So we're only determining whether or not we feel
I
his
mean, I lived
decision.
here
We're not
45
voting on the
years.
building right now.
I've lived here 45 years. I've helped half of these people get into office. I was very politically involved. It was a nice area. Now it's a three-ring circus. Believe me when I tell you, I live on the corner. It's awful. And this gentleman here, this attorney said, by putting a gymnasium in with 4 parking spaces, 7 parking spaces, You're not gonna add any more confusion to the area. Believe me, it's already confused. I mean, there's a lot I'd like to say, but I understand I can't. Is that correct?
That's right.
Well, thank you for your time.
Thank you very much.
Good.
Hi, Board of Appeal members. This is my first time. I'm Allison Durack, or Ally Durack. Hi, this is my first time.
You can move that microphone
can
up
hold
top
this?
if you want. It was just lowered.
Just put it on top of,
Is this okay?
put it up on the,
Or put it on the
here?
edge right, there you go.
there you go.
All right,
You're tall.
I'm tall? Okay.
Okay. Taller. I didn't say you were tall.
Taller.
Okay. Hey neighbors, hi everybody. I'm Allison Durack. Hi Board of Appeal, members,
Address.
members. Thank you.
What's your
So
address?
My address is 58 Floral Ave. I live by Forestdale Elementary School. I drive through Maplewood Square all the time, and I take my son and my in-laws to Franny's all the time, and we love it here. So I'm here specifically to support the building commissioner's support of state laws, apparently, for ordinances and setbacks. And I have a question for the architect. Who's the architect? All right. How many times have you submitted a permit that didn't follow setbacks for the state?
I don't think that's relevant right now,
Is it not? Well,
because we're just determining whether or not we agree or not, or disagree with Commissioner.
Because, no.
You can talk
You can talk.
about that, your support
Okay.
of the decision, or,
I'm just confused.
okay, great.
Okay, all right, so we'll skip my question. I just feel like if this is an unusual case, then it's not normal, which is not equitable, which is what you guys stand for in your first sentence of your website and what the lawyer presented you. It doesn't feel equitable to bring us all here tonight to not follow ordinances by state law. So, okay, I'm all done. Thanks, bye.
Thank you. Hi, just state your name and address, please.
I'm Megan Driscoll, and I live at 29 Columbia Street, and I'll keep my remarks to what they
Thank
should
you.
have to. I'm in support of Nelson Miller's decision. I think, we, through these presentations, have seen where maybe the Dover Amendment falls short. It definitely leaves a gap in who should be making these decisions. We see that other municipalities have decided to go with a site plan review. And I think that that's the best course of action because it's abundantly apparent that these decisions have an impact on the community, and it would be great if the community was given a voice. We know that that's not going to hinder necessarily the school's abilities or any school's ability to make these developments and expansions, but at least it will be something that takes into account the entire community and works in both parties' interests. Thank you.
Thank you. Hello, just
Hi,
state name and address.
Andrew Smith, 121 Flora Ave, and I'll be very concise. I'm here to speak in support of Nelson Miller's recommendation for a site plan review committee. Thank you.
Thank you.
Hi, my name's Samantha LeBlanc. I live on 30 Daniels, but I guess I'm going to talk about my mom, Renata LeBlanc, who lives on 12 Porter Street. We've lived here basically forever. She uses Salem Street to get to work, to get to Route 1, to get to work. Before, I think Mystic Valley bought the church, and when they did, traffic got terrible, and my mom hates using Salem Street now, so I'm in support of Nelson Miller's thing, but yeah, it's just traffic has been getting worse since mistake has been getting bigger. That's
Thank
it.
you.
Good evening. My name's Ed Fahey. I live at 24 Jacob Street. I also support Nelson's decision. I've had the pleasure of working with him through the authority, and I've never found him to do anything that wasn't helpful for us or the community that we live in. So I very much appreciate his efforts.
Thank you.
My name is Joy Pearson. I live in 193 Sylvan Street. I am in favor of this Nelson.
We just call him
Miller's,
Commissioner Nelson now.
Decision or statement. I feel, listening here, that the charter school is inconveniencing St. Joseph's School. The site, the picture that was there, and a statement, a couple statements, are that St. Joseph's are kind of hemmed in now, and they have no choice. I don't know. I heard that they bought the charter school purchased the property, but I wasn't told when, and I don't know when. I also am familiar enough with the Dover Amendment, or know enough about the Dover Amendment, that I think it's like something that people can always fall back on if they don't like something. And it's like clever people who can make 1 and 1 equal 3. And I know some very clever people here on the charter school faculty, relations, who probably are able to do that. That's beside the point, but I support doing something that has some consequence and allowance or a consideration of the people who live in this neighborhood and want this neighborhood to be a neighborhood. Neil Kinnan lives in our neighborhood too, but he doesn't want it to be a neighborhood. Their plans were long ago, and they are charting them out. They bought all of that property around there, so it seems that they had a plan to then hone in on that property. And who else? Anyway, I'm in favor.
Thank you.
Hello, I'm Brandon LeBlanc, 30 Daniel Street. I'm in support of Commissioner Miller. That's his name.
Yep.
Just a few quick thoughts. Even though I live in 30 Daniel Street, I live pretty close to Maplewood Square. I never go there. There's nothing there of value anymore because this school keeps killing it. Also, I don't know. I think that's all I'm going to say. I'm
Thank you.
in support of Commissioner Miller.
Thank you. Oh, just moving. Oh, thank you. If that's all, then the board will have a discussion, I guess, unless,
Could I have one final comment?
yes, you can.
So my final comment is, I hope this focuses more. I mean, we thought the board should grant all the relief. That's really doesn't seem to be the direction you're heading in. So I'm going to only focus on 2 points. One is there is a significant, where site plan approval is part of the ordinance, there's this, or bylaw, there's a significant question as to whether it's valid. And the case law isn't always entirely clear on that. But what is crystal clear is that where there is no site plan approval requirement in the ordinance, a Dover Amendment protected use cannot be required to go through it. and it's
Cannot
undisputed.
what, I'm sorry?
Excuse me?
I'm sorry, cannot go through site plan.
Cannot be
Where
required.
it's not part of the ordinance, where the ordinance doesn't say that in X situation you go through site plan. And that's exactly what we have here. We have site plan approval in the ordinance, but it doesn't apply. There's no question it doesn't apply. Commissioner Miller has admitted that it doesn't apply. But he thinks the, most convenient way or the best way to address it is to have it go through it anyway. But state law governs on this, and it's crystal clear from the Campbell decision, from the Montessori school decision, and there's nothing to the contrary, that where there's nothing requiring site plan approval in the ordinance, the protected use cannot be required to go through it. That's I just want to avoid any unnecessary time, money on that point. That's clear.
Thank you. So from what I am gathering, sure,
And then maybe close it to the
and then we're
public.
gonna close it. And it's
I
only
think the other
about,
thing it's also clear that whatever, if the decision is to relate to the site plan review, that there's no constraint on Mr. Miller of consulting other people in that. I guess that's the type of thing that maybe he doesn't follow that ordinance section, but it doesn't constrain him from getting assistance in the decision. I think that just has to be clear, so thank you.
thanks. So, public is,
I understand that it's probably going to go through. My name is Rosemary DeBianti, and I live at 26 Jacob Street, so it's in my backyard. I just hope that they're going to consider the neighborhood, because it's not even a neighborhood anymore because of what goes on there every single day. That's all I want to say.
thank you. Okay, so public comment is now closed. Any discussion from the board? So from what I can see from listening to this is, I'll go first, sorry. Nelson doesn't have the tools or the authority to make this decision one way or another. It had to go to somebody else because there's a gap in the ordinance that doesn't allow him to make this decision. And so, it's either, it's on us or it's on site plan review or, but it can't be on site plan review.
can't
So
be on
we
site-
need to say, can he make this decision or not?
Well, do you wanna go?
No, I was just trying to clarify. I thought we were here to make a call whether he made the right decision.
Right.
Right.
I mean, it's either, but I think that,
We can't tell him what to do.
Right.
Right.
right,
Okay.
I mean, we can.
But based on the ordinances, did he make the right decision?
That's what we have to decide. I mean, I think.
I
that-
can't make a motion.
I know. Well, I can always make a motion. I'm not shy about that. But, what I keep hearing is, again, I mean, there is, this Campbell decision, the different decisions that have come out is that he would need, our building commissioner would need direction from, again, the ordinances in the city. He gets
Can you
ordinances.
just speak in the mic, sorry?
He gets ordinances from the state. He gets some direction there.
Some there, some from the city, but there's a
But from the
gap.
city, there's a gap. I mean, that site plan review is not somewhere that he can go to, I don't think. So he has to, I mean, I'd make a motion that we grant the petition, instead of going on forever, grant the petitioner's request to overturn the building commissioner's decision, as it appears that, based on the evidence that we've heard tonight, that the city does not have a track for him to send them to site plan review at this time. And that he has to make the decision based on his other powers, the conditions that they bring up.
Does anybody want to second that or hear that again?
I keep waiting for Adam to say something, but.
Adam's not voting.
He's not voting.
No, he recused himself.
want to make it shorter?
Just repeat it.
Just repeat it. I make a motion that we grant the petitioner's request to overturn the building commissioner's decision, as the city has no ordinance requiring site plan review under these conditions.
So either you agree, say yes, or you disagree and say no.
Then he goes, and it's up, I'm sorry, but then it goes back to, but that's why it gets the big money.
I don't know if you're on.
I'll second it.
I turned you on.
Okay. A motion by John King to overturn the commission's decision due to the city has no ordinance requiring a site plan was seconded by Foyo. All right, we'll take the vote. Foyo?
Yes.
King?
Yes.
Bilgan?
Yes.
Codavarian?
Yes.
And Quinn.
Yes.
All right. Wow. Am I missing something?
Nope, that's 5.
That's all right. Oh, no, William, Codavarian.
He said yes.
He said yes, and you said yes.
Yep.
Okay. Got them all. 5 yeses.
You're getting rusty.
I
She's
know.
been out of it for a couple months.
Like, whoa. The petition is
So the,
granted. Is
well,
that
I'm not
5
sure
out
if it's a
of 5?
grant or.
Oh, it actually, it's
doesn't
an
really do anything.
upholding.
That's
No,
my
it's
point.
reversing
The
the
appeal is
decision.
granted.
The appeal is upheld.
Yes.
The appeal has been granted to uphold, to
Overturn.
overturn the decision. Thank
To
you.
go to, special advisory. That's the question.
That's all we're asked to do. That's now up to the building department. Goes back to them.
You got it, you can chair this meeting.
Would somebody like to make a motion to adjourn?
Oh, no,
Motion to adjourn.
Thank you.
second.
A motion by Foyo, second by King to adjourn at 8:58 PM.
It's Dover.
It's over.
Over.
Very adjourned.